Welcome back to Law and Crime this afternoon. I'm Aaron Keller. Glad you're with us. We're taking a look back at a case we covered very extensively here on the Law and Crime Network, and that is the Florida prosecution of Donald Smith. He was accused and tried on charges that he kidnapped and did a lot of other things to a young girl named Cherish Periwinkle. Why is this back in the news? It's back in the news because secret jailhouse recordings of Donald Smith himself, incarcerated, have recently come forward. We're going to listen to a little bit of those recordings. They are a bit disturbing. Let's go into those.
I have moved her out of the building. I'm not even asking. She just ran out. She attached herself to me. So I'm thinking about it, telling security, hey man. But he drives off. He's right in front of my van. He drives by. As she runs up, got my van going. She just comes right in the van. That's what I told Harry. He says, man, what she got in your van? He goes, fuck. How do you recognize a little girl? I don't view children as sexual objects. I don't view them as sexual objects or sexual partners. All I know is that I snapped. And the next thing I know is I'm sitting in the driver's seat of my van, and I'm breathing is ragged, and I look back seat. She's dead. I swear, I don't remember. I was so far gone.
Wow, disturbing discussions there from Donald Smith himself, the defendant accused of taking, sexually abusing, and ultimately killing that little girl in Florida. Attorney Nicole DeBorde is with us here on the Law and Crime Network. Nicole, good to see you this afternoon.
Good to see you as well.
These are really disturbing recordings, and they suffer from what we frequently refer to here as that memory fog, where he claims to have involvement in this chain of events, but doesn't seem to remember the really critical parts. Is that really any surprise to you?
It's not really a surprise at all. I mean, they oftentimes when they have done something as horrible as what this defendant did, don't want to articulate it. They don't want to say it out loud. Because then they have to really think about what they've done.
So real back and forth, though. I mean, at times during that recording, he says, "Oh, you know, I didn't do anything sexual with that little girl," and then later he loops back and basically says that he does. So, I mean, is he not remembering things, or is he trying to deliberately make it seem like he doesn't remember things?
I think he's trying to make it seem like he doesn't remember things. He's already made it clear that he thinks if he creates a psychological defense to his conduct, that he's going to be safer in prison. It also makes it easier for him to live with himself.
That could be one theory behind it, and we're looking back at some of those really disturbing images. Remember, folks, this was the case where Donald Smith took that little girl from a Walmart. That was the accusation. It was caught on that surveillance video that we saw right there. We saw his van pulling away. And later, that's the same van authorities said they found him in when they pulled him over. That's how this case unfolded. There are videos, there are pictures, and there is testimony from the crying mother of that little girl saying, Donald Smith approached us basically as someone who was trying to help us. I didn't realize that would result in a nightmare coming true. Let's look back to the prosecution's opening statement in that case.
Cherish Periwinkle was 8 years old. She weighed 67 pounds. Separated from her mother, her little sisters, from all she knew, escaping this world. She spent the last petrifying hours of her life with him. He gagged her. He raped her. He sodomized her. And then he strangled her. He gagged her with such force, her gums and her nostrils bled. He strangled her with such force, her eyeballs bled. Cherish did not die quickly, and she did not die easily. In fact, hers was a brutal and tortured death. And after he killed her, he pulled her little, lifeless body through the woods, pushed it under the water, forced it under a tree, and took asphalt, bricks, and debris and weighted her down. Because he planned for no one to find her. But as you know, things did not go according to his plans. He was caught. She was bound. And though not enough time to save her young life, and enough time to collect and gather the incriminating evidence of his guilt. Evidence on her body and in her body that would tell us, and now will tell you, the grim truth of her horrific death. So what can you expect? Defense counsel told you last week that the evidence in this case is both gut-wrenching and gruesome. Those were their words. It is graphic. It is disturbing. And while last week during jury selection there were moments of levity where we, and he, even laughed, I assure you there are no moments of laughter in this trial. I do not think it will be an overstatement to say that each of you will be changed at the end of this trial. The evidence is graphic. But every person has a constitutional right to confront the evidence against him, no matter the weight, the nature, or the volume of that evidence. It is your job to look at that evidence. The evidence of his destruction.
The purpose of the opening statements, obviously, to make it really clear what's going on as the prosecution pushes its case forward. I thought it was a very skillful way to put it. Say, hey, look, this is the defendant's right to take this to trial no matter the weight of the evidence against him. This is a case with a lot of weighty evidence. Let's listen to how the defense tried to deal with it.
Good morning. We are here in this courtroom because the state of Florida is seeking the death penalty. And you have just heard an emotionally charged opening statement designed to anger you. What we are asking you to do, as Americans in this country, is demand the state of Florida live up to their burden of proof, for they share it alone. Do not make any fixed opinion at this moment, but listen to all of the questioning, including the cross-examination. I will be upfront with you. There will be many people, Mr. Fletcher and I do not cross-examine. We will help you test this evidence that the state brings forward. And unfortunately with that, means that we will cross-examination. For the state told you that she traveled to this area about a mile from her house at about 6:30 at night, knowing that her daughter not only was going to California the next morning, but would have to get up at 4 o'clock in the morning to make a 6:30 flight. And so she brings these small children, 8 and under, one pushing a stroller, into the both Dollar General and Family Dollar. She uses $31 of the $100 that I guess she had allotted and bought miscellaneous things from the home. She decides against a $7 dress for Cherish. You're also going to hear, I anticipate, from 2 people that were married at the time, the Rosiers. They were in, waiting for their father with their little, I believe, newborn baby in the parking lot. And a white van comes over, and they roll down the window, and never having known one another before, this stranger says, "Follow us. We're going to get cheeseburgers." Ultimately, they will come in, and they will identify that stranger. And they will tell you, "We don't know if anyone else was in that van, but we literally thought Maybe we do know him. Maybe he somehow knows the father they were trying to wait. So they eventually go to McDonald's that's physically outside of Walmart, about 2 miles away. They didn't move him. All of these details will be important, ladies and gentlemen, for you to make legal decisions in this case. On June 22nd, 2013, a beautiful young child lost her life. And I won't mince words, it is horrendous.
Wow. Difficult opening statements in the Donald Smith case out of Florida. This is a case we followed very closely here on Law and Crime. Nicole DeBorde still with me here. Nicole, listening back to this, you know, where did the defense really have to go other than to just give the old generic opening, hold the state to its burden of proof? I don't think the defense had much else to go with here.
Right, and she said it right in the beginning. This is a case that was being tried because there was no other option. You cannot plead guilty to the death penalty. And so when someone is facing the death penalty, they have to have a trial and they have to be convicted. And so that attorney was doing the very best she could to create a defense there, or to lay out a case, because she was going to be sitting there dealing with that for the next however many weeks this case lasted.
Yeah, I mean, is this one of those cases that's really more so about the punishment than it is about the initial phase of the case where we determine guilt or innocence?
Absolutely. That's all this case was about.
So in other words, really, because the defense knew what was coming, there really wasn't that much else for the defense to do there other than to say, hey, look, you know, does this warrant that kind of a sentence? But also, you don't want to go too far down that road because you never know who may be on the jury.
That's exactly right. And, you know, the case has to be tried. You want to do your very best when you're the defense lawyer. You want to make sure you're giving the case every single piece of attention that it needs, that you're raising objections, that you're doing your very best to make sure that the defense is solid. But, you know, this is not a case that this defense attorney really anticipated would be anything other than a punishment case.
We're going to continue going through testimony in this case when we move along this afternoon here on Law and Crime. First, we'll take a quick break, then back with more in the Donald Smith case here on the Law and Crime Network. Wow, the mother of Cherish Periwinkle recounting that fateful night in June 2013 when Donald Smith took her to Walmart along with her daughter under the guise that he was there trying to help because he knew that they were in tough financial straits. Little did she know that Donald Smith, 61 years old, was 21 days out of prison and on the Florida sex offender registry when this was going on, and Cherish would not survive the night. Let's continue listening to that mother's difficult testimony.
Did he tell you that she was coming?
Numerous times I asked him, and he always said, she's coming.
Did you want to believe him?
Yes, absolutely.
The items that you'd stacked up for Destiny, for Nevaeh, for Cherish, did you have enough money yourself to buy those items?
No.
Why not?
Because the $100 bill that Aaron had given me, he had put a cap on it and said I could only spend 40 or 50 because I had to have enough money the next morning to take us to the airport.
So these items, absent his generosity, you could not have afforded these items?
Yes.
What are your girls doing during this time when you're picking out these items? What are the little ones doing?
Just playing, getting a little fussy because it was getting late. They hadn't eaten any dinner.
Just doing what kids do when moms are shopping?
Right.
At some point while you were shopping inside the Walmart, did the defendant make any mention to you about getting some food?
Yes.
What did he say and how did he say it?
He used his hand and he said, I'm going to McDonald's. What do you want to eat?
Sort of like a sock puppet is what you're describing to me?
I thought it was odd.
Where was Cherish when he said this to you?
She ran over to me.
Did she say anything to you?
Yes, she did.
What did she say?
She stood on my left and she said, he's got a $150 gift card. And I said, is that what he told you? And she said, we're going to McDonald's. What do you want to eat? And I said, cheeseburgers. And she said, cheeseburgers. And that was it.
At some point, did the defendant walk towards the front of the store where the McDonald's was?
Yes.
Did Cherish follow after him?
Yes.
What about the other two girls? Did they stay with you?
Yes.
Ma'am, why did you feel it okay to let Cherish walk to the McDonald's with the defendant?
If he would have asked me if he could take her, I would have said no. But because McDonald's is inside Walmart with people around, I knew she would never leave my side.
Well, you've seen the photograph in the state's exhibit here. Did you know and believe that there were surveillance cameras in the Walmart?
Yes, I did.
You knew the McDonald's was in the Walmart, right?
Yes.
Did you feel that if Cherish went to the McDonald's with him inside the Walmart that she would be safe?
Yes.
Had you known that they were going to leave the store, would you have let Cherish leave the store with the defendant?
No.
Did he ever ask you, can Cherish come with me to leave the store?
No.
Would you have ever let your child leave the store and leave the Walmart with this defendant?
No.
The testimony gets more and more emotional as we go along, as that mother gets close to recounting the moment when she realized that her 8-year-old daughter, Cherish Periwinkle, was gone. Nicole DeBorde is still with me here on the Law&Crime Network. Nicole, this is just that spiral that we know is going to hit bottom, but we wish we could go back and change things, because looking back at it, we know all the warning signs were present. This mother was in such difficult financial straits that she took this man at his word, thinking that he would indeed help out, that he would help buy this young girl shoes, that he would get her cheeseburgers. Little did she know that he was only out of prison for 21 days and was on the sex offender registry.
It's heartbreaking. I mean, really, the testimony doesn't really get much worse from a mother's standpoint. It's just absolutely horrible.
Let's talk about the prosecutor there asking the questions of that mother. I thought that the prosecutor did a very good job of asking clear, open-ended questions and clearing up a few things, because a few people on the jury might be sitting there saying, hey, why would you let your daughter go with this man you barely knew? And I think that the prosecutor did a very good job of painting her in as positive a light as possible. Do you agree?
I do, and that's part of the defense's case, as you heard from their opening statement, is that, you know, there are mitigating factors here. There are irresponsible decisions that were made by other people besides the defendant. And the prosecution is doing a great job of setting up how this really could have happened without a whole lot of carelessness on the part of the mother, as has been described by the defense.
It seems like kind of a ridiculous excuse, though, when you boil it down, though, trying to point the blame at this poor mother. I mean, yeah, maybe she could have made better decisions, but she's up on the stand breaking down in tears saying, yes, I could have made better decisions. I was gullible. That doesn't make the mother responsible for this. She's not the one who threw the girl in the van and took off with her.
Absolutely. I mean, it's just horrific. It's so sad, and there's just not anything about this mother's conduct that gives rise to responsibility for the horrible consequence.
Exactly. We'll be back with more in the Cherish Periwinkle case when we return here on Law and Crime. Welcome back to Law and Crime. Aaron Keller here along with you as we look back at the Donald Smith murder case out of Florida. This is a death penalty case where a 61-year-old man who was only out of prison for 21 days was accused of abducting, sexually assaulting, and killing an 8-year-old girl named Cherish Periwinkle. This case happened about a year ago, the original disappearance and death of Cherish Periwinkle back in 2013. We're talking about it again because recently released jail recordings of Smith himself talking about committing parts of the crime have recently surfaced. We're going to listen now to testimony from Charles Wilkie. He was the canine officer who discovered the little girl's body.
Now, you've mentioned that Gator actually, once he got off the tire tracks, he worked another track. Let me show you State 17. We describe for the jury what's reflected in State 17.
This is the path that Gator took down into the water line. He immediately took off. I went adjacent to him, so in case, and the reason I did that is in case he did walk up, he typically is going to track true, which means he stays right on top of the track. That's just the way that he usually tracks. And in doing so, I didn't want to walk directly behind him. I didn't want to mess up something if there was a footprint or if there was some piece of evidence. I didn't want to step on something that maybe I didn't see because I'm watching him. So I went adjacent to him and just paralleled him, and I would stop him periodically, and then I'd catch up to him till we got to the water line.
Testimony there from Charles Wilkie. He's the officer who ultimately found the body of 8-year-old Cherish Periwinkle after she disappeared in a van, prosecutors were saying, driven by 61-year-old Donald Smith. We're going to talk about this one now. Nicole, still with me on the line here at the Law and Crime Network, Nicole DeBorde. Imran Ansari also here in studio to talk about this. So let me throw this one your way. This officer had the difficult task of finding this girl's body partially submerged in water after the mother had made that frantic 911 call saying this man offered to help and now he's disappeared with my daughter.
I mean, it's riveting testimony, but this case is really one that the prosecution had with their opening statements. We heard some of the audio throughout the day when we've covered this story here at Law and Crime. And, you know, it's a riveting opening statement from the prosecution. It paints the really heinous crime that this individual committed against this young girl. And, you know, you have this testimony regarding finding the body from this officer. It's a riveting testimony in itself. But it's essentially the prosecution has to tell the story, paint the picture to the jury of from the crime, the events, after the crime, how the body was found. But I'm telling you, with this trial, with this case, I really feel that the prosecution had this jury with their opening statement.
Oh, exactly. I mean, the evidence was so strong in this case. Nicole, I think you'd probably agree with me. A lot of times we sit here and watch these trials go by and we say, gee, do we buy the state's theory? This time around, with the volume of video, the mother's testimony, all of that put together, was there much doubt from the first minute of this case that this particular defendant was the guy?
Not at all. I mean, this is a punishment case, like we've said from the beginning. The defense is doing anything and everything they can to try to avoid the death penalty. It's not about guilt or innocence. It's just absolutely devastating testimony. And this officer will never get over having found this child in this condition. It's a nightmare.
We're going to go back after we come back from this quick break and listen to some jailhouse recordings from the defendant himself. Stick around. We are talking about the prosecution of Donald Smith of Florida, who was tried about a year ago for the death of an 8-year-old girl named Cherish Periwinkle. Among the more disturbing pieces of evidence in that original case, which is back in the news because more recordings of him have been released, was this recording. This is a recording jurors heard. It's of Donald Smith himself behind bars awaiting trial, talking to fellow inmates, giving up a few details about Cherish Periwinkle, the victim herself.
Here it comes. No one in the back.
Detective Carter, The voice that you just heard that said the one in the back, is that the inmate who was housed directly adjacent to the defendant, Donald Smith?
Yes, sir.
Second voice that's on that recording, is that the voice of Donald Smith?
Yes, sir.
Okay, the person who said they're about 12.
Yes, sir.
Officer Carter, the person who said, that's my target area, that's what I go after, whose voice is that?
The defendant's.
Officer Carter, the voice that just said, I'd like to run into her at Walmart, is that the voice of the defendant?
Yes, sir.
Let me just inquire. The voice that we just heard that said, Cherish have some butt on her, that was not this defendant, correct?
Yes, sir.
That was the other inmate in the adjacent cell.
Yes, sir.
She ain't acting like that, though. That's because she ain't black. She had a lot for a white girl.
The last voice that was depicted there that said, because she ain't black, but she had a lot for a white girl, was that the voice of this defendant?
Yes, sir.
Officer Carter, this recording was made 2 years after the defendant was arrested, wasn't it?
Yes, sir.
Thank you. I don't have any further questions.
With comments like that, it is not a surprise that this resulted in one of the fastest convictions we've seen here. It was about 15 minutes, maybe a little bit less, and then ultimately a jury recommended the death penalty for Donald Smith. Nicole DeBorde on the line with me from Texas. Nicole, not a surprise in that verdict at all, especially given statements like that from the defendant himself.
Exactly. I mean, this testimony is so bad that whoever's filming this occasionally pans over to the court reporter, who usually has no expression on her face whatsoever in a normal trial. This poor woman just is looking around the courtroom. she can't believe what she's hearing. It's that bad.
This is one of those things that makes a defense attorney remember, Imran Ansari, to tell his clients to not say things when they're in jail.
That's correct. You know, that's one of the first things that a defense attorney should tell their client, because no matter what state you're in, that was in Florida, I've experienced here in New York, they're going to be recording the phone calls. They're going to be recording around the ambient conversations around your cell. And all that stuff could be used against you at trial. Now, what are you going to do in this case? This case, listen, if you're the defense, what are you going to do with that? I have a feeling that prior to trial, they were trying to get the death penalty off the table. The prosecution said no way. They were forced into the trial, and they were just trying to get that capital case down to a non-death penalty sentence.
And it didn't happen. Look, we're going to take another quick break here on the Law&Crime Network. When we come back, we're going to move back into the two cases that we would be covering this time if they were in session. We're following, of course, the McStay family murder case out of California, and also the case out of Iowa of a mother accused of neglecting her 4-month-old son to the point that child died. Those cases and more when we come back from this break here on the Law&Crime Network. Stick around. Welcome back to Law&Crime, ladies and gentlemen. We're talking about two cases now here on the network. One is the prosecution of Cheyenne Harris. She is the Iowa woman accused of killing her 4-month-old child, Sterling Cohen, by basically neglecting him, leaving him to rot in his own feces and a child swing. This is the second prosecution related to that infant's death. That case is on hold today. The state rested at the very end of last week. The defense is preparing its case. We should see live testimony in that case tomorrow. Also, we're talking about the California prosecution of Charles Chase Merritt. He's the man, Southern California prosecutors say, killed a family of 4, the McStay family. Basically, here's the accusation. Chase Merritt struck all 4 members of that family with a sledgehammer and buried their bodies in the Mojave Desert. That is the accusation against Chase Merritt. The question is whether prosecutors are doing a good enough job in this allegedly months-long trial of pointing the finger directly at the defendant. Do they have enough to get him, or is the state just raising a lot of questions and not giving clear answers? Let's listen to some testimony from a Detective Ryan Smith in the Chase Merritt case.
Why didn't you test them before?
Because it was abundantly clear they didn't drive themselves to the desert in their car, bury themselves, and then drive their car to the border.
But his vehicle was not found at home, correct?
That's correct.
So the vehicle had to be driven at some time away from the home.
Correct. And as I indicated, that key is clearly a copy.
Please answer the question that I only asked. And he had house keys also in his pocket, correct?
Yes, sir.
So if you have house keys and car keys in the pocket of your clothes, is it not a reasonable inference to look at from an investigative standpoint is, did Joseph drive that car to San Diego? Where it was found.
I'm not sure I understand what you're trying to get at, but again, my testimony is that it was abundantly clear they didn't drive themselves to the desert and then drive the car down to San Diego, and that key was clearly a copy.
Right. But did you eliminate the idea that they drove the car down to San Isidro and were taking there until deposited in the desert?
Objection calls for speculation.
Question was, never instruct anybody to question him about the sale of the business.
I did not instruct anybody, no.
Did you subpoena the contract for the sale of the business?
I did not.
Relevance.
I did not do that, no.
Did you make any effort to determine the terms of that sale?
Objection lacks foundation.
Again, no, I didn't do anything with Mr. Kavanaugh.
So the defendant is saying he was not involved in the deaths of this family of four, and that another man who had his fingers on the finances, named Dan Kavanaugh, is the one authorities should be looking at. So why didn't that particular detective actually dig into Dan Kavanaugh the same as he dug into Chase Merritt? What was going on in the minds of the law enforcement officers, and is this sloppy police work? Those are the questions the defense wants people to ask, and a lot of people are asking them. Let's listen now to a Detective Ryan Smith again here on Law and Crime.
We can't tell you either way. We tried to compare, but we don't have what is suspected to be a cover from the laundry room in San Diego's search warrant anyways. So I can't compare that to the cloth that Joseph was wrapped in. I can tell you it's consistent, but that's my personal opinion. I don't have any technical knowledge on that. I feel that that cover that Joseph is wrapped in could be the futon cover. I can't tell you if it was or wasn't, but the futon cover was big. Joseph was 6'1".
Okay. Simple question. In all the photographs you saw, and people you talked to, the futon cover had zippers, correct?
I believe it did, yes.
Did you find any zippers in the grave on any of the blanket material?
No.
And when you testified just here in your answer, you said other people told you the futon cover wasn't in the house. Is it true they told you it wasn't on the futon?
You're grouping a lot of people into one, but suffice to say they couldn't locate the futon cover.
That whole discussion has to do with the futon cover, other pieces of linens that prosecutors are trying to say came from the family's home and wound up in the family's grave. They keep trying to link these things up. Imran Ansari, the prosecution has married itself to this theory that this family was killed in the family home, all four members, and then somehow carted to these graves in the desert. Why are they trying to make that link? They don't have blood. They've got these little shreds of fabric and things like that they're trying to match up. I mean, is that really relevant to whether this defendant is the killer?
Right. You know, they have married themselves to that theory. And I think as this trial goes on, you could see how that theory and that marriage to that theory is creating a real problem for the prosecution. Because you have a circumstantial case here. And when you have a circumstantial case like this, you really want, as a prosecutor, you want to be able to connect the dots almost seamlessly from the crime scene to the crime to this defendant, which is on trial. And, you know, you hear the testimony from Detective Smith. You see other points in this case and evidence which is presented, which really, you know, there's some reasonable doubt there. And if I was the defense in this case, I'd be taking point by point, making notes. And when I'm up there on summation, I'm telling this jury, reasonable doubt, reasonable doubt, reasonable doubt. You have all these points of reasonable doubt that you can't convict my client based on that.
These are all the points that the defense is making. Certainly, we've heard bits and pieces of them as we go into the testimony. Let's listen now to an FBI forensic examiner who's trying to match up paint from the family's home with paint found on items at the scene, rather, not the crime scene, but the grave site, the graves where the family was buried.
You haven't actually seen the items, correct?
Saw them, I tested them.
You saw the actual items, or you saw scrapings from it?
I saw scrapings from it.
So this is an item that's the sledgehammer that the scrapings came from that you tested for one of the two items. And this is the bra. The bra is more important to me, since you are an expert on paint. They described the paint on the bra in the report submitted to you as a drop on the bra. Looking at 746A, would you consider that just a drop?
Objection, argumentative, calls for speculation.
You want me to say this is a drop of paint?
How would you describe that paint on the bra before you in 746A?
How would I describe this paint?
Would it be more than a drop?
Objection, argumentative.
Depending on how much was splashed onto it, it could be one drop, right? It's paint on the bra.
Is that, because you talked about based on your analysis of that item, that the paint went onto that item and likely cured by air.
Objection, speculation, foundation.
Overruled, she can answer if she has an opinion on that.
Did you read the question?
In your report, you talked about how the paint scraping that you analyzed, it appeared to be paint that was on that item and cured by air.
I would agree with that.
What does that mean when you put in your report that it's cured by air?
What I mean is that I believe that this paint was wet when it was dropped onto the bra, and then it dried in place. That's how it got on here. Dropped on and then dried.
Now, the other paint that was scraped off from the hammer, how did you describe, do you think that got put onto that? Do you remember?
No, I don't remember.
Looking at the amount of paint on that bra, does that seem to be sufficient amount of paint if it wasn't dry, when it came in contact with something else, it could transfer just by touch?
Objection calls for speculation. Overruled, she can answer if she has an opinion.
This paint has what looks like drops going down, so that's partly why I think it would be liquid when it dried on here, because it's got gravity pulling it down. So I think this was put on here wet, and then it dried in place.
And if something else, say the hammer came in contact with the bra, when it's still wet, would that be allowed to transfer onto the hammer?
Objection, speculation.
Overruled, she can answer if she has an opinion.
If paint is wet and something else touches it, yes, I think it can transfer.
And that can be from direct transfer or me touching something that's wet and touching something else when my hand's still wet with that, correct?
Depending on how much paint would be on your hands, yes.
And do you see any paint on the handle of that sledgehammer that would be consistent with what you tested? If you could take a look and see.
Object as to speculation and foundation.
Overruled, she can look at it and see if she has an opinion.
So I had pictures of these items in my notes that I was using as well.
Do you have those notes with you?
Those notes were provided in discovery.
No, but do you have them with you? In case you need them for reference, because I have them.
I have a copy of my notes.
Okay. If you need to refer to your notes to help kind of refresh your memory and see where it came from.
So again, there are authorities trying to basically match up items of paint found in the graves of the victims with paint in the family's home. So Imran Ansari, again, we're in this matching process. We've got, this little shred of a scrap of what they believe to be a bath mat or a towel. And they think that that matches up with missing bath mats and missing towels, rather, in the family home. And now they're trying to do it with this paint. Do jurors really get anything out of this, though?
Well, really, they're trying to link up the forensic evidence. You have to do that, especially in this case, because this case is heavily forensic. However, I think there's going to be problems, because we have to think that in 2010, when this case first hit the desk of the police department there in California, it was a missing persons case. It was treated as a missing persons case. That means that critical time period after this family went missing, after that they were murdered, they weren't doing that investigation that the police would do at a homicide scene. They were treating it as a missing persons case. You heard that there was video footage of a family that, the defense is definitely going to be trying to point to be the McStays. They were crossing that border into Mexico, and the police weren't looking at this as a homicide case. So originally, when they did that investigation at the home, it wasn't a homicide case to them. So we already know that there was vital evidence at the home that was probably destroyed or went missing. So the prosecution has to use what they have to really get whatever evidence out regarding this forensic evidence that they have, and they need to link the gravesite to the home.
Yeah, they don't have a lot there, though. That's the thing. I mean, they're taking weeks and weeks and weeks to drag this out, and it's like, okay, well, where's the smoking gun evidence? Where do we prove that it's this defendant that you're dragging in front of a judge and a jury to put on trial? Okay, so you got a scrap of fiber here, missing linens in the bathroom. Okay, maybe it matches. You know, how many of them are sold? A lot of people have white towels. A lot of people have white bath mats. How does that indicate that it's Chase Merritt, who's the guy that did this family in?
Right. Unfortunately, Aaron, I don't think it does. I think they're trying hard. They have to deal, you know, it's the deck of cards they were dealt, right? So they have to use the evidence that they have at their disposal. They have to get the testimony out from their law enforcement witnesses that they can, anything to link this crime to Mr. Merritt. But unfortunately, there's a lot of reasonable doubt here. There's a lot of questions as to the sufficiency of the law enforcement investigation in this case. Then there's that third person, right? Kavanaugh. And, you know, if I was the defense attorney estimation, I'd be pointing that finger at an empty chair. Where is Mr. Kavanaugh? Well, we know that police didn't do the right job, or at least we would be arguing that in terms of investigating that.
The original investigation was botched. You know, how does Kavanaugh link to it? These are all great questions.
Right.
You should give the closing here. I think the defense has got some great ideas in this case. The defense doing a lot of its own investigation. So we'll continue talking about the Chase Merritt case when we come back here on Law and Crime. In the meantime, we want to remind you about a hearing that's coming up tomorrow that we're planning to cover live. That's an important one. This is the case involving Luanna Simon, the former Michigan State University president, accused of her alleged role in the Larry Nassar gymnastics sex abuse case. A preliminary hearing tomorrow will determine if there is enough evidence against Simon to bring her on trial on charges that she lied to authorities about her level of knowledge about what Larry Nassar was up to there. We remember Nassar accused by more than 100 gymnasts of sex assault in a number of locations over a period of many, many years. That hearing will be happening tomorrow here on Law and Crime. We'll take a quick break and be back with more in a moment. Welcome back to Law and Crime. Aaron Keller with you this afternoon as we look back at testimony thus far in the California prosecution of Charles Chase Merritt. He's the man that authorities in Southern California have accused of killing a family of 4 business associates. The family, Joseph McStay, his wife Summer McStay, and his 2 young boys were all found dead in shallow graves in the Mojave Desert. The question is whether Chase Merritt is the real killer or whether it's someone else. The defense is directly pointing to a man named Dan Kavanaugh. Could he have done it? Or is it someone that no one is talking about? There's a lot of questions in this case. Let's listen to a recording of the defendant himself. This is when he spoke to police.
Do you know his credit card number? I did the QuickBooks Pro, and I do the credit card. All I needed it for. He just wrote it down? Yeah, he just wrote it down. So you'll see on one of his whatever credit card, because I don't even remember which one it was. I don't think it was Visa. I think it was. Do you remember what bank? I have no idea. And when did you do that? Was it prior to February 4th? No. It was 2, 3, or 4 days after February 4th that I actually bought the QuickBooks. Joseph and I sat down and talked about the QuickBooks because Summer didn't know how much money Joseph actually made, and she never did. And one of Summer's biggest problems is credit cards. I mean, she spends a lot of money. She goes to Ross all the time, things like that. So it's a big thing. It had become a big thing with Joseph, not letting her know exactly how much money he's making because when she knew how much money does he make? Do you know? I know by what we do. He does very well with the custom. I don't know what he does with production waterfalls. I have no idea because I don't do any production waterfalls. So what do you know he makes? I'll show you. I was building every waterfall all myself, and I was dying. You know, that's what gave me a heart attack, actually. It was because we got really busy last year, and we were just really cranking. What's Dan's role? Dan was the witness. He actually, to the best of my knowledge, he owns part of Earth Inspired Products. Joseph was buying him off. Him and Joseph kind of had they weren't real happy together. Or Joseph wasn't real happy having to pay him so much. Do you know what he paid? I have no clue. I have no clue. Joseph didn't tell me a whole lot about it.
And you, Joe, and Dan all lived in the same apartment at one time at the beach?
Oh, no, I've never met him.
Oh, you never met him?
No, I've never met Dan. The first time I talked to Dan was a week ago or a little less, or when all of this started. Dan called me and said, "Hey, dude, what are we going to do?" I said, "I don't know. I don't have any access to, Joseph's emails. I don't have any access to any of this. I can't help him." And so Dan said, "Well, I can send you any pertinent emails if you can follow up with them. Any complaints, any problems with customers, can you try to deal with them so that when Joseph comes back, at least we've made an effort to, get the stuff taken care of."
What date was that,
These can be those really critical words, folks. The defendant himself talking to police, giving his version of what was going on when Joseph McStay and his family disappeared. Still here in the Law and Crime studio with Imran Ansari. So, look, this was a small business, this Earth-inspired products, this business where you've got victim Joseph McStay doing work with this defendant, Chase Merritt. So they're sort of spinning around in their little orbits. There's money back and forth between McStay and Chase Merritt all the time. It was kind of like a running tab. One owed the other money, back and forth, back and forth. And look, that's the way small businesses oftentimes operate. But then you throw Dan Kavanaugh in the mix, and then he's got his hand in the financial pot as well. Now, is any of this that clear link prosecutors want it to be? Because it seems to me that Kavanaugh's got his hands in the money, and that Merritt has got his hands in the money, and neither of these two are trained accountants doing things the way that they probably should be done. But does that add up to some kind of motive or intent or anything like that?
Right. So let's take it first on the prosecution side. So the prosecution is going to really want to flesh out and point out the financial motive for the defendant to have murdered Joseph McStay and then his family. So they're going to point to all that other forensic evidence. We talked about the crime scene and the gravesite evidence, but the forensic evidence, which would be the financial forensic evidence, which would be the evidence of checks being written to Chase Merritt, cashed and then deleted. They're going to show that financial motive for Chase Merritt to have murdered Joseph McStay and his family. But then let's take it from the defense side. Now, the defense side is also going to be pointing to this financial motive, but not necessarily for the client, the defendant, but to Kavanaugh. So you have this sort of triangle of small business owners and partners, and there's a real financial motive. But again, that's that shred of reasonable doubt that is enough for the jury to acquit if the defense really points that out. If they show that Kavanaugh is possible suspect, there you go.
We're going to take a quick break here on the Law and Crime Network and be back with more in the Chase Merritt case when we return. Welcome back to the afternoon session here on Law and Crime. We're going to shift gears now and talk about the Cheyenne Harris case out of Iowa. This is a case where a mother is facing a murder charge and other charges related to the death of her 4-month-old infant, Sterling Cohen. Bottom line here, the mother is the second to go to trial over the death of this infant. The first was the father. He was already convicted. Now it's time for prosecutors to go after the mother on that law in Iowa that says that if you endanger the life of a child and the child dies, it automatically leapfrogs and becomes murder. That's the law in that state. That is why these are relatively easy convictions to get in Iowa. Let's listen to some testimony from this case. This is from a babysitter, a neighbor who lived near the family of the woman charged.
So did you see Cheyenne Harris arrive home?
I did.
And tell me what you mean, how you saw her.
I seen her walking up the sidewalk. I could hear their car pull up. They didn't have the quietest car, so I heard them pull up and seen her walking up into their apartment.
And what time of day was that?
I'm not 100% sure.
Did you watch Sterling overnight?
Yes.
Would it have been the next day?
Yes.
After Miss Cheyenne arrived home and you saw her walking into the apartment complex, did she come directly to pick up the children?
No.
What happened?
She had texted and said that she needed a minute, if she could have a few minutes to just get herself together before coming to get the kids.
Did you agree?
I did.
What happened next?
Nala ran out of milk and she was on her last diaper, and I drew her a text telling her that it was time that she needed to come get the kids.
And did she come get the kids?
No.
Well, how long was it after she arrived at the apartment complex and she said she needed a little time? Did you reach out to her and say that she needed to come get the kids?
I don't know how much time had passed. I just knew that her baby needed milk and needed diapers, and they were starting to get fussy.
And you told her that and she didn't come right away?
No.
What happened?
Me and my boyfriend and I ended up grabbing the kids' stuff, and we brought them over to her.
Why did you do that?
Because Nala was fussy. She needed a diaper change. She needed milk. Things like that.
What happened when you went to the defendant's apartment?
Ms. Harris came to the door and seen that I had brought the kids over to her, and she kind of rolled her eyes like she wasn't ready to have the kids back.
And did you give her the kids?
Yes.
Was that the last time that you saw Sterling alive?
Yes.
How did you learn that Sterling had died?
I was freshly out of the hospital, just gotten home. I went outside for a cigarette, and I noticed that Mr. Cohen was outside. And I said hi, but he didn't say anything back to me. So I walked over to him, and I said, "Is everything okay?" And that's when he stated to me that he was gone. And I said, "Who's gone?" He said, "My boy." I said, "What do you mean gone?" "He's just gone," he said.
And what did you say next?
I don't remember exactly what I said next, but I said, "You mean he's dead? He's gone?" I don't know.
What was Mr. Cohen doing?
He was outside smoking a cigarette.
Did that upset you?
A little bit. I told him, I said, if your baby's gone, I said, "Have you called anybody? Have you called 911 or anything?" He's like, "We don't know what to do." I was like, "Well, you need to put your cigarette down, and you should probably go inside and call 911.
Did you see Miss Harris?
I didn't see Miss Harris for some time had passed there.
Cheyenne?
Yeah.
Can you tell us about that interaction?
They were talking about funeral arrangements and some stuff like that. And at some point, she had looked at me and Zach and said, "It seems like everybody's pointing their finger at me." And I agreed with her. That's exactly what it seemed like to me. Like everybody was pointing their finger at her.
And what did she say in response to your statement?
At that time, she kind of winged her arm out over to Zach and said, "I told you we should have taken Nala, Leo, and ran."
Should have taken Nala, Leo, and ran?
Yeah.
And Leo would be the dog, correct?
Yes, sir.
Did you respond to that at all?
I didn't know how to respond to that.
Okay, so the baby is dead. The parents are talking about it with a neighbor, and they make this weird comment saying, maybe we should have just fled the state and not reported it or something like that. Like, what's the logical outcome of this? Imran Ansari, what do we make of this? I mean, this is not looking good for this defendant.
No. I mean, this case is another case which just really shocks the conscience. You had this child who was found in horrible condition before his death. You have a defendant, one defendant's already convicted, the husband. You have the second defendant, now the mother, on trial. And now, the jury is going to be looking at the mother, under the lens of how could you do this? How could you let this happen? Now, in Iowa, they call it diminished responsibility defense. That's what they're going to be going for, and an intoxication defense. But the facts, I feel, and the evidence that's coming out during this trial really don't support that. You have this 2-year-old sister who was in seemingly good health, whereas this poor child, this infant boy, was in complete neglect. It really doesn't show that she didn't have the state of mind in order to, keep these children healthy.
Yeah, this is a tough. That's all coming up now that the defense, is getting its case. But first, let's listen to some of the defendant's own words. This is her police interrogation.
Well, let's go back and let's go back like the full 24 hours, and so let's start from like yesterday morning. Can you run me through yesterday morning in as much detail as possible?
She woke up for whatever reason, and normally when she wakes up in the middle of the night, unless I get her back to bed ASAP, she ends up trying to stay up until Dad gets home. At least that's how it's been lately.
And so she hops in with you, and then you soothe her enough, eventually she goes to sleep?
No.
No?
No.
Okay.
It isn't that easy.
What happens then?
Her eyes were closed. She does this thing where her eyes are closed, but she'll still pat around for you, and she does this, if she doesn't have a stuffed animal in bed next to her, she takes your arm, wraps it in the blanket, and cuddles that. Well, that wasn't comfortable enough, so she kept flopping around. She couldn't decide if she wanted me to lay on her arm or her to lay on my arm or to lay on the pillow. She didn't know if she wanted to lay on her stomach or across me. So finally, I got back up, I got her a sippy cup, and I tried laying her on the couch in the living room again. That didn't work. So I tried changing the movie. That didn't work. So I tried bringing her back into bed with me. That didn't work. So I tried the playpen. That didn't work. So I just let her go for a minute. She ended up on the couch again. That's where she fell asleep for a short time. Well, no. She ended up on the couch again. And then I knew she wasn't done being up because I could still hear her in there talking. And she ended up back into bed with me. I was playing a game on my phone. And she watched that and fell asleep. And then that's when I got up and did some dishes because I figured Zach would be home shortly.
Okay.
And then she got back up. I don't even think she was out for hour, maybe, before he came back in and she was up.
We are seeing a real conflicted version of events here, conflicting versions of events in the death of Sterling Cohen, that 4-month-old who that defendant, who you just heard in a police interrogation, seems to indicate was just fine not long before he died. So Nicole DeBorde is still with me here on the Law&Crime Network. Nicole, I got to ask you about this. In one breath, she's saying, I fed him hours before he was discovered dead. But then the family's telling the neighbor, maybe we should have grabbed the other kid and fled, took off. So which is it? Is this someone who's struggling with guilt, or is this someone who ought to be guiltless?
I think it's someone who's struggling with guilt. I mean, it's such a terrible, terrible thing that can't be taken back. I mean, she ignored this poor child to the point of it passing away. And, it's kind of hard to live with yourself. And that's something that you've let happen. So I think she's kind of vacillating between fear and guilt, and I can't be responsible for this.
Imran Ansari, we are waiting for the defense to pick up its case in chief. That will start tomorrow. We've heard depression leading to self-medication. Okay, methamphetamine use. She admitted to that during that interrogation. Where does it go from there, and how successful could that defense be?
Right, so the defense is going to start their case tomorrow, as he said, and they're going to be calling mostly like psychiatrists, psychologists to opine, give expert testimony to the jury regarding their observations, their analysis, their look at the totality of her mental state, right? And they're going to be opining before that jury regarding possible postpartum depression. I believe that's within the notice that the defense has given to the prosecution, regarding methamphetamine use, so drug abuse. But I want to take a look back at that statement that we just heard, and you hear Cheyenne Harris recounting how she's really looking after her 2-year-old. 2-year-old's coming to the bed, and this is the night before the death of little Sterling. 2-year-old's in the bed. She's getting the sippy cup. She has the wherewithal to recount to the police about the different positions that Nala was in and not being able to sleep. That doesn't sound to me like someone who has an intoxication defense.
Yeah, there's the 2-year-old in this home video with the father already convicted in the death of little Sterling. So yeah, I mean, can you have your cake and eat it too when it comes to this kind of a defense?
You can't. You can't. And that's the problem for the defense. They're going to have to put that out. But again, I think this is a case of the defense looking to mitigate the exposure of their client, the defendant, take it off the first-degree charge to a lesser-included charge to avoid the life sentence. In Iowa, it's no death penalty, but it is a life sentence for first-degree murder. They want to look to mitigate that down, possibly get second-degree murder or manslaughter, and I believe in Iowa that's 50 years max.
Yeah, Nicole DeBorde, I want to ask your take on this here, too. What do we make of this? We heard the defense say off the top of this case, look, the defendant is not a monster. She's just struggling with all these issues. Are jurors going to take the defense's word at that, or are they going to throw that right out and say, hey, look at these autopsy photos of this rotted baby's corpse?
You know, I mean, that's the worst thing about a case of this nature for the defense are the autopsy pictures. I mean, the jurors are going to be forced to look at a picture of a dead little baby, and that's an incredibly emotional and devastating thing for them to see. It doesn't really reconcile with the type of care that this particular defendant is describing, but it is very clear that there were a lot of other personal problems going on for her, and maybe that will be mitigating.
Exactly. A lot to talk about when the defense starts its case in chief tomorrow. We will be covering it live here on Law and Crime. We'll take a quick break and come back with more as we discuss the Cheyenne Harris murder trial in Iowa when we return. Welcome back to Law and Crime, ladies and gentlemen. We're talking about the Cheyenne Harris murder case out of Iowa, where a young mother is accused of murder basically for neglecting her 4-month-old infant to the point the infant died. It's been a back-and-forth blame game. When the father was on trial, the defense has asked to call the father to testify in this case. That results in a big mess. Even though the father has been convicted, he still has Fifth Amendment rights, and that will turn into the possibility that the father could be called and he would get up there and plead the Fifth and not answer the questions put to him. We're going to listen more, though, to Cheyenne Harris's police interrogation.
I apologize because I haven't been at your house or your place, so I don't know. Where was Sterling?
In the next bedroom in the suite.
Okay. Was the swing turned on?
Not at the time, because after a while it shuts off. So normally I have it playing or moving on a slow motion with a little mobile, and it plays music too.
Okay. So Sterling was in the swing, but the swing wasn't moving at that point. Okay. when you found Sterling, did you take him out of the swing, or is he still in the swing?
He was still in the swing.
Okay. And when you get Zach, then what happens after you get Zach?
After some freaking out and having no idea what to do or say, he called the ambulance.
Some of the defendant's police interview there talking about just exactly what was going on in the death of Sterling Cohen. Nicole DeBorde is with me here on the Law and Crime Network. Nicole, we see these pictures of the defendant putting her head down, not really wanting to listen to a lot of this evidence that pertains to her. But look, facts are facts, and the facts are going to be tough to overcome here. Nicole, I can't hear you at all. Sorry about that. I think you muted on your end. Imran Ansari is still here, and I know that I can hear your voice. So we've got just a couple of quick seconds here left. But again, I was saying facts are going to be difficult to overcome for the defense.
Right. Right. And, you know, a big part of this trial, I think, has been her demeanor in court. We've seen a few shots of her where it's almost like she's confused of how to express her emotion. There's been some smiling or smirking, and I know that that won't play well in front of the jury. I mean, she's 20 years old. It could be her age. I mean, she's confronted with a serious, serious crime.
Exactly. Look, this is going to be a defense case starting tomorrow. I'm curious to see what experts the defense brings in. Want to thank you, Imran Ansari and Nicole DeBorde, coming to us out of Texas. That's going to wrap up our 9 to 5 coverage, but I will be here in just a few seconds with the Daily Debrief, our recap of what's been going on throughout the day in the legal world. We've got a lot of interesting cases, including a discussion of legal events surrounding the Super Bowl. Stick around.